what questions you guys might have. So I'm going to stop talking, and I will let you guys ask away.
Well, this is Joan, and my main question is whether it would be worthwhile for me to set up a living trust. I have only my daughter as a beneficiary. I have a house and a number of mutual funds, IRAs, 401k, and I've already made her the beneficiary in most of those things. So would it be simpler and worth my while to set up a living trust?
So without going into more detail, Joan, and really sitting down and looking at everything that you have, I would say that, whether putting together a trust, putting together a will, or doing, planning of some sort. I mean, I can say that putting some sort of plan in place for sure would make sense. And that's, I'm always going to say that. And it doesn't matter if we have, one child that we're leaving everything to, or 3 children that we want to split things up between. The reality is, and I don't want to be a downer by any means, but there's a reason why we plan, and we know that things can happen that we don't expect. And the last thing that we want is to sort of have everything that in order, at least we think we have everything in order, and then sort of something happens, and the plan that we had in place is no longer the right plan. And so whether that means that somebody that we're leaving money to passes away before us, or maybe they become disabled, maybe something in our life changes at some point, and we decide we want to have the flexibility of leaving something to some other people, or smaller percentages of what we have to someone else or somewhere else. So I would say that it would make sense to sit down, and whether you sit down with me or somebody else, I think it makes sense to sit down with an estate planning attorney and sort of discuss things, because I think that having something in place for sure makes sense. I don't really love the idea of just relying on beneficiary designations. And one thing that we can't necessarily just solve with the beneficiary designation is when we own real estate. And so if we own a condo or a house, we typically want to do some sort of planning with respect to our real estate. And I can definitely say that the last thing that myself and most estate planning attorneys would recommend is the idea of, adding an adult child onto the title of our home. And that's just because, if something happens to them, somebody wants to sue them or come after them for any reason, or they get married and get divorced, that house is theirs. It's as much theirs as it is ours. It doesn't matter that we're just sort of putting them on the title as a matter of convenience. There can be some negative consequences to that, depending on if they run into some trouble, or if they just have a liability that pops up, and that could be like hitting somebody with their car, or whatever that might look like. The reality is that we plan for the worst and we hope for the best, right? And so I know I'm kind of giving you a very long-winded answer, just because it's not that easy. It's not. I can't really just say yes or no. There's really more to it. So I really think it would make sense to sit down with somebody and discuss your specific circumstances, probably in a little more detail, and figure out what's right for you, because there's probably a plan that you should put in place. It's just what's the right one, and whether a trust is the best plan or not, I don't know. But it would really be sitting down and kind of looking at everything and trying to see what we're looking to accomplish, and making sure that we're just thinking through everything in as much as we can.
Okay, thanks.
So I hope that didn't confuse you too much, but it's about the best I can do.
No, I've been thinking anyway that I would get around eventually to making an appointment to come in and talk to somebody there. So
sure.
I will do that.
Okay.
So turn on.
Thank you.
Yeah, of course, my pleasure.
Matt, I will go ahead and put your email. Oops, Matt, I will go ahead and put your email in the chat for everyone to see that.
Confirmation email, the link was not an actual link.
Yeah, I don't know why yours turned out that way, because for mine it was a link. So I'm if you ever have any other issues, feel free to give me a call. I'll be more than happy to help you get in.
Yeah,
Yeah,
Thank
I
you very
have a
much.
feeling that we are,
okay.
Enjoy the
I don't know
program.
why Heidi's on here right now.
Hey,
Matt,
Bob.
hold on one second.
Hello? Yeah.
I don't know, these people are talking over here. I'm not sure if they're supposed to be on this link right now. Heidi?
So I just,
Okay, let's see. Okay, go
Hello?
ahead, Matt.
okay.
Go
I
ahead,
just,
Matt.
Kim, I just put all my information in the chat, by the
Oh,
way.
perfect.
Yeah, I got it all handy, so I threw it in there. So Helen, you sent me a message in the chat, but you sent it directly. Well, I guess I should, well, either way, there's a question in the chat. What kind of considerations should be considered in making the transition from a home to an assisted living facility? So anytime that we're thinking of making any kind of transition, whether it's from our house to independent living, assisted living, you know, there's a couple things here, right? So number one, I typically advise, and then I give this advice to most every client I sit down with and that's thinking about making a move. Number one, we want to make sure that we're making the right move. And so if we're, the question might be, are we looking at what are our needs? And so if we're moving to we're moving out of the house into some sort of long-term care community and, assisted living, independent living, which really isn't any kind of care setting. Typically, I'm recommending that a client would sit down and maybe meet with a geriatric care manager. I say this because a lot of times people aren't really sure of what the right move is, and whether Gene, I know you. Okay, there. Thank you for muting. So I think the reason for the geriatric care recommendation is that a lot of people, I think, don't know exactly what that right transition is. I think that because there's assisted living, there's independent living, where some people can have some legal considerations. All right, so I will finish this and then I'll go into the legal consideration part, because I think this is important. I think it's important because just a lot of people sort of have this idea that they might need a certain level of care. And so just in general, I'll say that I think meeting with a geriatric care manager is always a great thing, because they can really sit down with you and kind of figure out, what are you looking for? What can you do for yourself? What can you not do for yourself? And then, they place a lot of their clients in assisted living facilities and nursing homes and supportive living facilities and independent living facilities all the time. And so they really do know the ins and outs of a lot of these places and can really make some good recommendations. From a legal consideration standpoint, I think that if we're moving into assisted living or any kind of community, I think this is a time when we need to be looking at we should be looking at our documents, right? We should be looking at our powers of attorney. We should be looking at our wills, our trust, because if we're moving into some sort of long-term care community, it means that, we might be declining in some respect, whether it's physically or cognitively. We typically don't move to an assisted living facility because, we're at a point where we can do more. Typically we are all of a sudden needing some help with activities of daily living. And so if we are starting to decline in any fashion, again, whether it's cognitive or physical, it's probably a good time to revisit all those estate planning documents. Let's make sure that everything is in place, and that the documents that we have are what they should be, right? Has anything changed since we put these documents in place? Would we benefit from changes? Did we name our son who lived down the street from us as our, power of attorney for healthcare and property? But, since in the last 10 years, he moved to Seattle and he's not as available. And our daughter who lives in Wisconsin or Indiana might be the better person, right? Because they're both just as capable of helping us out, but maybe the one that's a little closer might have a little bit of an easier time, if we needed them. So I think one piece is making sure that all of our documents are still good and that we have the right people named and they're, nothing needs to be changed. I think the other thing is, depending on where we're moving, are there any benefits we can apply for? So assisted living is always going to be private pay. So if we're talking about assisted living specifically, that's a private pay scenario. There's no Medicaid for assisted living. But based on somebody's assets and whether they served, they're a veteran and served during a period of wartime, maybe we have the ability to apply for the aid and attendance benefit through the VA. Maybe this is a time where, we need some help with activities of daily living, but not all of them. Maybe there's a way that we want to protect some of our assets, and so, in case, 4 or 5 years from now, 3 years from now, if we need to go from assisted living to skilled nursing, do we want to do any kind of asset protection work where we can try to protect what we have so that in case we ever need long-term care, we might be able to, in a nursing home, we might be able to set our assets aside and apply for Medicaid at some point. So there's different considerations that can come up. I think a lot of it might be, I think in general, it's not a bad idea for somebody to reach out to an elder law attorney when they're, making this transition, any kind of transition here where we're bringing a caregiver into the home, we're starting to transition to any kind of community. I think, again, and whether it's me or somebody else, it doesn't matter, but I think sitting down with an attorney who does have a concentration of their practice in elder law, it's people reach out to us all the time in these situations, and sometimes it's just we sit down for an hour, we look at everything, we discuss what their goals are, and sometimes it's sort of the answer is, all right, well, based on what you're looking to accomplish and based on where you're at, there's really nothing you need to do. And then obviously, there's other situations where we say, maybe these documents should be updated, right? These are pretty old. Things have changed since you put them in place 10, 15 years ago. Maybe you didn't do all the planning that you should have done. Maybe there are certain documents that you should have in place that you never even put in place in the first time. So I think it's just wanting to make sure that things are all buttoned up. Because again, especially if we're moving into some kind of long-term care community because of any kind of cognitive issues, if there's any changes that we have to make to any documents, we need to do this now, right? We need to be able to do this while somebody still has capacity to update their documents. Once somebody loses capacity, now they don't have the ability to update those documents or do any additional planning. And so, the sooner the better as far as sitting down and taking a look at things. So I hope that was a helpful answer. I know I kind of went around in circles a little bit. Some of these are good questions. Some of them just, I don't have a, yes or no or, 1, 2, 3 answer to. So if you feel I didn't answer that question in full, please let me know. I'm happy to answer more.
Can I ask another question?
Of course.
About that.
Well, this is a question about the beneficiaries that you talked about earlier.
Mhm.
So my sister and her husband are going through her father-in-law died and they're going through the whole business right now. And he had a trust,
Sure.
but most of his assets were in various different kind of accounts that had beneficiaries. And they're working through that, and it is a little difficult to work through all the beneficiaries because every organization has a different way of dealing with those beneficiaries. But generally it's working out okay. Some of them are more organized than others. But you said you distrusted some of this beneficiary things. Why is that, and what is your experience with those things?
So let me clarify. I appreciate you saying that because I want to make sure we're on the same page here. I want to be very clear. I don't distrust the idea of naming beneficiaries. Not at all. Not at all. And just in general, and to comment on that, when we name beneficiaries on an account, the beneficiaries on my IRA or on my mutual funds or on my CD will supersede the beneficiaries that I've named in my trust or my will. So an account that I have that has beneficiaries designated on it, let's say that the beneficiaries of on a CD that I have are the beneficiary is my wife. But let's just say that the will or the trust I have in place says everything goes to my 2 kids. Well, that CD will go to my wife because a beneficiary designation on any kind of account will supersede the language in my will or trust. The will or trust will control the language, the beneficiary the the beneficiaries in a will or trust will control any assets that I have that are in my name only that don't have beneficiaries named on them, or any assets that I have that are titled in the name of my trust. And then that's where my will and trust will come in. So, but to get to the idea of not trusting beneficiary designations, really what I mean by that is the fact that things can happen. And I think that a lot of people sort of just rely on this idea, and I'm not saying it's terrible. I just think that we've seen situations where, people think they're all set, right? I don't need a will, I don't need a trust, I'm just going to put beneficiaries on every single account I have. Well, until they realize that, one of their beneficiary, their sole beneficiary doesn't survive them, or their sole beneficiary is in an accident and has special needs and is receiving Medicaid or some government benefits, or they have two beneficiaries named and they don't realize that if one of them passes away, the other one gets everything instead of the deceased beneficiary's share going to his or her kids, which is what the person would have wanted. So that's all I mean. I mean that there's just some things that we might want to put a little more thought into. And it's sort of, again, what's the ultimate goal here? And I get that a lot of the things that we're going to say with our clients, like I said, we plan for the worst, we hope for the best, but we're planners at the end of the day, right? And so we've seen things that can happen that, granted, probably aren't going to happen 100, aren't going to happen even close to 100% of the time. But it just, we bring them to light with clients because we want them to understand, what possibilities are out there. And the question just becomes, if we're comfortable just naming beneficiaries and that's what our plan is going to be, and that's fine. We just want to make sure that people, know the pros and cons of that and want to make sure that they're taking everything into consideration before they decide that this is the right plan for them. So I hope that clarifies things, but in general, I mean, if you've got beneficiaries named, I'm not concerned, with the current situation, at least that you seem to be, that you mentioned with the relative who passed away. So there's a question in the chat box. What kinds of considerations need to be considered in looking for an accountant to handle things during the estate administration? I will say that, most CPAs, most accountants out there, I've been doing this for 10 years. I don't think I've come across an account, a CPA or an accountant that has not been able to handle an estate tax return, which is what we're talking about, an estate tax return or a trust return if we've got a trust in place, excuse me. So I don't know what more considerations we really need other than obviously making sure that accountant or CPA, it's something that they've done before, right? We want to make sure that they, over the course of their practice, they've filed estate returns, whether it's for a probate estate that we have in court, that they filed trust tax returns. So I don't think it needs to be anything more complicated than that. I think we just want to make sure that this is something that they've handled before. Again, I think you'll find that most CPAs probably have handled that before. I don't believe it's all, extremely difficult, but I'm sure you'd find some that have never done it. And so I think that's just a question you want to ask to make sure they, it's something that they're comfortable with and that they've handled in the past. And if obviously anybody's ever looking for a recommendation, we can always put you in touch with a CPA or accountant that can help with that.
So I've got another
A
question.
follow-up question?
Another question.
Sure.
There's always this big debate between going through probate and having a trust, and of course these days most people have a lot of designations in beneficiaries on accounts, and so you have those wouldn't, just like you said before, those would not be covered under a trust or the will in probate. But is there, I've looked online, I haven't been able to find this. Is there sort of a step-by-step guide to what are the steps that an attorney would lead people through to do probate in Illinois, so that you know you have to go to the judge, you have to make this submit this document, then you have to put this in the newspaper, you have to wait this amount of time. Is there some sort of guide to probate that could help people like us who are, in our family, we've generally only had wills, no trusts. And it's always been a good experience. It hasn't been a bad experience. But anytime you talk to a lawyer, probate is a bad experience. So I'm just interested in finding out some way to really evaluate this.
Yes. So my short answer is I don't have any kind of guide. There's no guide that I'm aware of. I mean, it doesn't mean that there isn't one out there. It's a great question. There very well could be. Some people handle, I would say very few, but some people, can handle a probate estate pro bono. They don't hire a lawyer, and they can go to court, and you might be given some direction from the clerk in the courtroom, but I mean, they're not an attorney, and they're going to, provide some guidance, but it definitely won't be all of it. I mean, the big difference, honestly, between probate and avoiding probate, and again, so like you said, and you're right, a lot of times, people will use a trust to avoid probate. And for most clients, I'll say 95% of the clients we work with in our practice, we're putting trusts together to avoid probate. It's not because they have a large estate that would be taxable by Illinois standards. So it's not like we're setting up the trust or trusts to avoid estate taxes. It really is to avoid probate and to create a more simple administration. There's some attorneys that have that mindset. I'd say more of our colleagues than not sort of have the mindset of, listen, I'm never going to tell people probate's terrible. We're just going to be very upfront with them and tell them from a legal perspective, from our perspective, and looking across and discussing with our colleagues, there's time involved regardless, whether we have a trust in place or whether we go through probate. The big thing becomes with probate, 9 out of 10 times the executor of the estate is hiring a lawyer. And so the biggest difference between probate and not going through probate are the fees. I mean, if we're looking at, an average probate estate, probate estates, they really can range, but I don't think that we're going to see a probate estate from start to finish, even if it's really simple, with attorneys' fees and court costs involved, probably not looking at less than $5,000 or $6,000, and that's really on the low end. We've had some that that are not extremely complicated, but where there's depending on the people we're working with, there's a decent amount of hand holding that they need. We've got some that go up to $10,000 to $15,000. So I would say it's not that probate's awful. I just think that in a lot of cases, it's sort of the idea that we can put a will together, and we can most attorneys will charge less to put a will in place, but a lot of times we know that in just putting a will together, we may very well have the probate when somebody passes away, and so there will be additional fees at the end. And so really that idea behind putting the trust together is that it will be a little bit more expensive up front. I mean, I can't speak for other attorneys. It's not going to be a huge difference. But putting that trust in place over the will definitely, if we look at all the costs combined, would be less expensive than putting a will in place and then dealing with the probate costs later. So I know I kind of elaborate a little bit there, from the question of just is there a guide out there? But I really do want to make sure people understand. I mean, at the end of the day, people just need to decide what they're comfortable with. When it comes to estate planning, our goal is really just to educate people and provide options. And people just need to understand, hey, listen, if we're going to put a trust in place, this is how it's going to work. This is what you're likely going to be dealing with. If we're putting a will in place, this is how it's going to work. And this is likely what you're going to see. And there very well may be probate that you're going to have to go through, right? Or not you, but your loved ones. So, there's no, I really don't want to say there's a cookie cutter plan for anybody. I think it's just, what are an individual's goals, and then just offering options as to how they can accomplish those goals, and letting them decide what the best fit is.
Question.
No, he didn't hear you.
I have another question.
About
So,
Okay.
Either with a trust or with a will and probate, the executor is sort of the key person in this thing. My brother-in-law is an executor of the estate that I'm told you about before, and he's dealing with it. Fortunately, he has my sister to help him, who is pretty experienced in dealing with these things, just because we've had a number of deaths in the family, and she's dealt with all of the estates. But he has brothers and sisters. It's not real complicated. They're all working together. But what kind of advice can you give for choosing executors out of your family or out of professionals or what?
Yeah, so that's a great question. I mean, when it comes to naming executors, we have to be thinking about, realistically, and obviously we can't really look into the future, right? I mean, it would be great if I could look into the future and say, well, if I die 40 years from now, this person will be the perfect executor, right? It doesn't work that way, right? All we can really do is think about, well, if something happened tomorrow, who do I know that I think would be capable and willing to step in and manage my estate, right? Because all we can really do is think about tomorrow. We can't think about the future, right? We don't know what's going to happen because the perfect executor that I name for tomorrow may pass away before me, may be incapacitated at the time I pass away, just may be too busy in his or her life that at the time I pass away, they can't take on that role. And they don't have to, right? Just because I name somebody as an executor, they don't have to step in and act. I can't force them. And so, I'm going to say that across the board, at least with our clientele, right? And we do a number of plans on an annual basis. I'm going to say that 95% of our clients are going to pick an individual that they know as either an executor of their will or trustee of their trust. For better or worse, it's because a lot of times people have this idea of, well, if I'm, when I pass away and I want everything to go to my kids or my grandkids or my nieces and nephews, I want them to work with somebody that they know, right? Whether that be, their uncle or somebody who was a really good friend of the family or somebody that was very close. A lot of times there's this idea of, yeah, you know what, I trust my brother to step in and manage my estate and take care of my kids. I trust my sister, I trust my cousin. And so I think a lot of people, and I'm going to say most people, are going to really sort of start, I think their first thought is going to be, who is close to me that I really trust to step in and manage my estate and make sure that my beneficiaries are taken care of. So, I mean, again, I've been doing this for 10 years, and I'm just going to say, again, I'm going to say 95% of the clients I've worked with in the last 10 years, and it's probably more than 95%, to be honest. It's probably 98%, are picking an individual. And whether that individual is a brother, a sister, a mom or dad, a niece, a nephew, an adult child, typically they're picking an individual. And in every situation, I'm telling my clients, I want you to talk to the people you're thinking of naming. Make sure that they're willing to do it. You may find out from them that this is not something that they want to do. They're not comfortable doing it. Great. It's just as beneficial for me to know that they don't want to do it than it would be if they did. Because if they don't want to do it, then I need to put some more thought into it, right? I need to think of more people. The last thing I want to do is just name 4 people thinking that, yeah, sure, I really like these people. I really trust them. No problem. They would for sure do it. And then a year later, after I put the documents in place, I'm talking to a couple of them and realize that, 2 of the 4 people would have no interest in doing that, and they wouldn't be comfortable doing it. Then there's obviously situations where people just don't have anybody that's close to them that they really trust. They have children that don't get along, and they don't want to name one of their 3 children to be the executor of their will or trustee of their trust and manage and in charge of the estate if he or she doesn't have a good relationship with the other 2 siblings, right? We don't want to create a situation where our kids like each other even less when we pass away, because those situations happen. And so in those situations where we don't have somebody that's close to us that we can name, then we are looking at a corporate trustee, and whether we're looking at a bank or a trust company, But those are typically going to be the options. The days where people, named the attorney that they were working with as their trustee or executor have kind of gone by the wayside. I mean, every once in a while, I think, you'll see attorneys out there. Maybe it's a client that they've worked with for 20 years, and they'll step in and be willing to act as executor or trustee. But that's pretty few and far between. You don't really see that a whole lot anymore. We have a practice in our office that we don't take that on. We work with enough clients, we do enough estate plans that, if we said yes to everybody that asked, we would, at some point, we wouldn't be able to draft documents anymore. We would just have a professional trustee practice. And those practices exist as well. So I think in all these cases, it really is, when we're talking about naming executors and trustees, I mean, in these situations, there should be, I would think there should be an attorney involved. And so it really should be, discussing this with the lawyer and going over the specific, the details of the family dynamics and we have not seen everything, but we have seen a lot, right? And once you've been doing this for more than a couple of years, you've probably seen enough situations to kind of know, what people should try to avoid, and then what situations tend to work out. Again, knowing that not everything's perfect.
I've got a follow up on that, just to, talking with my sister about how it's going, on this estate, and talking with some other people about estates, all of them with trusts, is that the beneficiary thing, I mean, the executor thing is a little complicated, because these organizations, let's say you have beneficiaries on 5 different accounts and an insurance policy or something like that. These companies only want to talk to the executor. They won't talk with anybody else. And in addition, these places lose documents. So you send them documents about what to do, they lose, so you've got to continually follow up. And of course, nobody ever answers a telephone anymore. So this executor thing is somebody has got to be very patient and sort of skilled in dealing with people in order to get these organizations to sort of respond. It's not a simple task.
Yeah, I mean, and every situation is different, right? Some are easier than others, but you hit the nail on the head. And what we tell clients typically is when it comes to thinking about naming an executor or a trustee or a power of attorney for property, it doesn't need to be, my son, the lawyer, my daughter, the financial advisor, my niece, the CPA. A lot of us kind of think of those people in those professions as being like, oh yeah, of course they'd be a good executor or trustee, right? I don't know why, but they're a professional and they deal with money and they know the law and they know taxes, and so they'd probably be a good fit for that role. I think at the end of the day, when we look at who's the best fit for these roles, it really my 2 cents to clients is who's good at managing a household, who's good at making sure that bills get paid on time, right? The taxes are filed when they should be. When something breaks down in the house, we're on the phone and we're calling somebody to come and repair it. This is going to be typically a more equipped executor or trustee, right? We want somebody that's just going to be able to stay on top of things. Somebody that can't manage their own life, somebody that has their own, a messy personal life, probably isn't going to be somebody that we want to name, right? Because if they can't manage their own thing, their own life, how are they going to manage ours? So you're right. I mean, and things come up, but I mean, as far as the fact that these places will only talk to the executor, I mean, that's just how it goes, right? That's no different than right now. I mean, if I've got an IRA at Vanguard, they're only going to talk to me. They're not going to talk to anybody else. So that I get can be annoying, but that's just how it has to be, right? There's no other way to do that. in some situations you might find a place where, I can give them permission to speak to somebody else, but some places just won't do that. And they say, you know what, you've got to be on the phone. We're not going to allow you to delegate that to somebody else. So. Well, we got about another 15 minutes or so, which we don't all have to be here for, but if somebody's got a question, I'm happy to entertain it.
All right, Matt, I think you have answered everyone's questions. Any last comments? Anybody?
Going once.
Going once, going twice. All right. Well, Matt, first of all, thank you so much for being here with us today. We really appreciate it. That does conclude our YES educational series presentation. On behalf of the North Suburban YMCA and the series, we thank you for supporting our organization and programs like this. Again, special thank you to Matt. In fact, Matt usually speaks with us, I think once or twice a month. So please check him out in the summertime. Programs like this one is free and open to everyone in our community. So if you enjoyed today's program and would like to support the North Suburban YMCA, please consider helping with a donation at our website at www.nsymca.org. We also hope to see you on our next speaker series, which is actually tomorrow. And let me just get to that. And that is about strategies to maximize your Social Security benefits and guaranteed income. And that is tomorrow at 11 a.m., also free and open to the public. And you can actually register at our website at nsymca.org as well. All right, thank you to everybody. Enjoy your summer. It's a beautiful day. And Matt, we'll see you at our next speaker series.
Great, Kim. Thanks, Kim.
Thanks, guys.
Thanks, everybody.